Welcome back to On the Ground. My name is Benjamin King. I'm the CEO of Kinyu SCM, a supply chain focused employer of record on the ground here in China. Today, we're in Guangzhou in this lovely office, and I'm joined with two legal experts from both China and the UK, and we're going to compare the differences in labor law between China and the UK. So today we have James Peng from PW Law Firm and Partners, as well as Sue King Solicitor from Wrigley's Solicitor Firm. So welcome, James and Sue. Why don't we get started and you can give a brief introduction of yourself?
Thank you. So hello, everyone. Thank you for having me. So my name is James Peng, and I have been experienced employment law for more than 20 years. And our law firm, PW Partners Law Firm, so we have more than 50 lawyers, and which is specialized in company law, employment law, IP, commercial disputes resolution, competition law, and I'm very glad to be here. Thank you so much.
Thank you, James.
As Ben said, my name's Sue King. I came to Guangzhou on holiday, actually to visit Ben, who's my son, and he somehow managed to find me a job while I'm here. So, but I'm more than happy to oblige, and I'm looking forward to finding out the differences between UK and Chinese law. So I've been an employment lawyer in the UK for about 25 years. I started off with a big international law firm called Eversheds, where I did lots of commercial type work with big sort of household name companies. Then I moved on to a smaller firm, slightly more family-friendly arrangement, and I worked with SMEs, so got experience of working with smaller companies. And then I moved to Wrigley's, where I became a partner and worked with charities, sort of local government, hospital trusts, etc., not-for-profit type organisations. So my main interests really are in looking at employment status and the issues that that creates, and discrimination law. So I shall look forward to finding out how that works in China.
Brilliant. Yeah. So thank you, Sue, for taking time out of your holiday today to come and join us today. So before we really get stuck into this episode, I want to just go through the why we think this is really important, because China, James, you can agree that China is sort of almost known for being very employee friendly, almost to the point that it's quite intimidating and maybe even a barrier for companies to actually set up here. Set up company, maybe employ people here on the ground. But I think that this is mainly because it is compared to the US labor law, and the US being a sort of a benchmark, because a lot of the business which is that China does overseas is obviously with the US. It's one of the largest trading partnership in the world, and they're both equal counterparts in terms of size of economy. So I think China labor law definitely gets compared unfavorably from US labor law from a company point of view. So today we're actually going to compare the UK labor law, employment law, and Chinese labor law, look at various different rounds and see how it all compares, really. And also just make sure that you like and subscribe to this podcast, and wherever you're watching it or listening to it. As you see, we brought on different experts from accounting, legal, and also foreign managers who can give you good advice and tips on how to manage your team on the ground. Right, so round one, as we compare different elements of the employment law, labor law between China and the UK. So is overview of the sort of different legal systems, between China and the UK. So James, do you want to just give me a bit of an overview of the labor law?
Okay, I think it's a very meaningful things to compare with Chinese employment law with other countries. because they can clarify a lot of issues from the overseas. I think China's labor law system consists of both national and local regulations and forming a comprehensive legal framework. So at the national level, the core law is the labor law of the People's Republic of China, supplemented by the labor contract law, the law on mediation and arbitration of labor disputes, the social insurance law, and others. On the top of this, local governments formulate supporting rules tailored on local conditions. For example, Guangdong province issues the wage payment regulations, which provide more specific guidance on wage payments and labor supervision. And in addition, there are judicial interpretation from the courts, which provide guidance for the specific cases. I think this is a simple introduction of the legal system of employment.
Okay, great, thank you. And yeah.
So that's interesting because obviously the UK is a much smaller place than China. So we don't have regional, well, I say we don't have regional differences, not significant. But when I'm talking about UK law, I'm talking about the law in England and Wales. It is slightly different in Scotland and Northern Ireland. But within England and Wales, it's all the same. There are no different regional differences. And it's very much based upon statutory law. So the laws that are made by government, similar to what you've just described in China.
Yeah.
But I get the impression that the other aspect of employment law in the UK is case law. So that's come from judgments. So when people bring claims against their employer, it goes through the courts, the judges pass down a judgment, and that provides some guidance and interpretation to the statutory law, which I get the impression forms a bigger part of the employment law sort of makeup in the UK than it does in China from our discussions. Would you say that's probably the case? And then that obviously makes it a little bit more uncertain for employers in the UK because they don't know what the judges are going. Nobody knows what the judges are going to say at the end of the day. And so I think that does. I think that provides a bit of uncertainty. Whereas you were telling me that actually, is it like once a year the judges will review cases and then pass down some sort of advice that might be used?
Yeah. So I think that in China, so maybe our verdict will be in public. So we will research the case from the website, so we can analysis about the result of the case. So the similar results of the similar case. So this is one part of our work. And on the other hand, the Supreme Court, the Chinese Supreme Court will issue some interpretation about the employment law case, so to the public. So I think it's a very important to lawyer because actually it's a guidance. So we know actually the similar case, maybe the court will give this verdict. So we will tell this analysis, this legal analysis to the client.
Okay.
Yes.
Yeah.
So
that
this is
is
our
similar.
this is our
Similar to
part
the
of our
UK.
work. So yeah. So I think in China nowadays in China the statutory labor law is very important, but the case so it actually is important too for us. Yeah. Okay.
And in China, so I mean, it's interesting. Yeah, of course, across different provinces, things like minimum wage can be different across different provinces, can't it?
Minimum wage,
as an example of a policy, is different.
Yes, different from the cities because for example in Guangdong province, the Guangzhou and Shenzhen is a high level, maybe another city is a middle level, maybe as a east of the Guangdong province, some cities is the lowest, is a different, it's a different level, the minimum wage.
Yeah.
Yes.
Yeah. So there is a variation there, but
Yes,
it's
very local.
but it is quite sort of transparent and clear.
It's transparent. Every year, maybe the government will issue the minimum wage minimum every year. So maybe every year is different. So the clients must notify this notice to invest to change his contract.
Yeah. And also just in China about the labor bureau that employees can seek help from. Can you just explain, which is obviously free and available to anyone?
Yes, I think China's labor bureau and arbitration institutions can support the employees in case of employer violate such as failure to sign the contract or wage deduction, or inspectors can interview directly and order correction to the company. Normally, the inspector will call the company and ask the HR to review this HR and ask them why your company violate these matters. And for disputes over contract termination or work injury compensation, employee can initiate arbitrations for free of charge in arbitration institutions. So I think the government gives a lot of support to the employees to protect their rights. Yeah. Okay.
And in the UK, just going back to how sort of case law is such a big part of it. Do you have like an example of when a company is maybe being caught off guard by the case law?
Yes, I've been thinking about this, and I think one of the biggest ones most recently was a case of Harper Trust in Brazil. So basically, that was about how to calculate holiday pay for employees who don't work all the year round. So they're part-time, but they also don't work all the year round. And although companies have been following the government advice, which was because that sort of calculation is complicated, more complicated than the sort of normal permanent employees. So they'd been following the government advice. But this lady who was an administrator in a school brought a claim because she said her holiday pay wasn't being calculated correctly. So despite the courts agreed with her, and it went from the Employment Tribunal to the Employment Appeal Tribunal to the Court of Appeal and then the Supreme Court, which obviously took quite a long time, years, 2 or 3 years, or I think it was. And ultimately, the Supreme Court agreed with her. So in the meantime, you've got companies that are following government advice. Then they've got this hiatus, this period of time for 2 or 3 years while they're waiting for the courts to decide, and then they have to recalculate the holiday, and the employees would have backdated claims for holiday pay that had been calculated wrong. So I think that's a fairly good example of how tricky it can be for employers when the cases are literally reinterpreting the law and how long it takes to go through the legal system. Also, though, we do have a system in the UK. ACAS will support employees, like you were explaining, with the Free Labour Bureau. But they don't intervene to the same level as the Chinese bureau. I mean, they will sit on the sidelines and support, but they don't actively intervene.
Okay.
But they are free.
Yeah.
They're free.
Yeah.
Yeah. So overall, to summarize this, labour law obviously statutory in both countries, with various cases that can then alter the application of the law. Maybe a bit more sort of transparent and clear planning for companies here in China, but sort of naturally more employee friendly from the point of view of the Labour Arbitration Bureau.
Yeah.
But in the UK, a bit more complex, a bit more difficult to plan, based on the fact that some judgments can really overturn even government advice, and how many companies have been working retrospectively.
Yeah.
So yeah, that's round one.